In 1907, a Manhattan lot began to be taxed, managed, and inherited as if ownership had changed. Yet no signed contract, no clear deed, and no recorded transfer existed. What followed wasn't a clerical error, but decades of decisions built on silence. This video examines the Golden Age agreement that only survived in letters and silences, focusing on a decision quietly anchored inside the New York County Clerk's office in 1907. The mini-verdict is simple and unsettling. A transfer of control occurred without the document that should have authorized it. The evidence begins with a dated registry index from that year showing fiscal and administrative effects where no executed contract appears. At the turn of the 20th century, Manhattan was transforming at a pace few cities had ever known. By 1907, corridors once lined with private residences were being recalculated into financial instruments, office buildings, long leases, and parcels whose value depended less on bricks than on certainty. Land was power, and certainty was the currency that allowed families, banks, and municipalities to plan decades ahead. The public image of order relied on ledgers that aligned with law and on records that could be pointed to, copied, and defended. That year was already marked by instability. The panic of 1907 shook confidence in institutions that had previously seemed immovable. Newspapers tracked failures, consolidations, and emergency interventions with clinical attention because reputation mattered as much as capital. In this environment, every recorded decision carried weight beyond its immediate effect. A single notation could alter tax obligations, influence inheritance planning, or determine which name would endure on a building's cornerstone. It is within this context that a specific Manhattan lot begins to behave strangely. Municipal use records, fiscal assessments, and later succession decisions all treat the property as though control had passed from one party to another. Restrictions are enforced, usage is assumed, future heirs make plans that presuppose a settled agreement. Yet when the expected foundation is sought, a signed contract, a deed clearly conveying title, it is not there. What exists instead are references, letters that acknowledge an understanding, administrative actions that proceed as if authorization were already settled, and an absence where a formal instrument should reside. Nothing about this absence announces itself. There is no public dispute in the press of the time, no dramatic courtroom confrontation recorded in headlines. On the surface, the system appears to function smoothly. Taxes are levied, estates are calculated, clerks index outcomes, not intentions. The machinery of record-keeping does what it is designed to do. It normalizes what has already been accepted as fact. This is where the tension sharpens. Publicly, the era prized transparency through documentation. Privately, decisions were sometimes resolved before paper caught up, or never did. Reputation demanded stability, and stability discouraged questions that might expose uncertainty. In families whose names were already woven into the city's identity, the cost of formal dispute could outweigh the risk of quiet accommodation. The absence of a signature does not stop the effects from compounding. Over the years, the understanding becomes functionally indistinguishable from law. Later clerks inherit earlier assumptions. Successors rely on predecessors' annotations. By the time modern researchers encounter the file, the outcome feels inevitable, even though its origin remains undocumented. If this intrigues you, what would you check first? The index ledger, the correspondence file, or the gap where a deed should be? And subscribe so you don't miss the next document, leaving a like if this line of inquiry matters to you. What follows begins not with a revelation, but with a space, a registry entry, a year stamped in ink, and a file The closes without the paper everyone assumes once existed. In 1908, 1 year after the Manhattan lot began to behave as though it had already changed hands, a single piece of correspondence entered the historical record through a path it was never meant to take. The document surfaced not in a public registry, but within a preserved set of private letters later donated to the New York Historical Society, catalogued among personal papers rather than legal instruments. Its presence there is the first concrete element that allows the investigation to move forward, not by interpretation, but by exposure. The letter is dated clearly, written on heavy stock consistent with professional correspondence of the period, and folded in a manner typical of outbound mail rather than internal memoranda. It was preserved alongside unrelated family communications, travel notes, and financial reminders, material that had no procedural obligation to survive. The action that matters is simple and verifiable. The letter was preserved, retained, and later reclassified as part of an archival donation rather than filed, indexed, or registered as a contract. That path alone places it outside the mechanisms designed to give agreements public force. What makes the document unusual is not its tone, but its structure. The language outlines conditions, time frames, and responsibilities with the cadence and vocabulary used by legal offices in New York at the beginning of the 20th century. Phrases indicating delivery, compliance, and assumed control appear without hesitation. Obligations are described as active rather than contingent. The text refers to actions already underway, not proposals awaiting approval. Yet the letter contains no appended exhibits, no reference numbers, and no indication that it was ever submitted for recordation. The absence is not subtle. There is no signature block formatted for execution, no witness line, no notary mark, and no indication of filing. Intent. The document does not point to an accompanying deed, nor does it reference a clerk's receipt or registry stamp. In a period when even provisional agreements among elites were often duplicated and retained by counsel, the lack of formal attachments places the letter in a category it should not occupy. It reads like an endpoint while existing as a fragment. The concrete action within this block is the comparison itself. Terms in the letter align closely with those found in contemporaneous property agreements handled by established Manhattan law offices. This is not an interpretive leap, it is a textual match. Identical phrasing appears in contracts of the same year, governing land use, transfer conditions, and duration of control. The letter mirrors the operational core of those instruments, but not their form. It functions socially as a contract while remaining structurally incomplete. The consequence of this mismatch is measurable. Subsequent administrative decisions, tax, assessments, usage allowances, and inheritance assumptions treat the obligations described in the letter as settled facts. The paper trail that follows behaves as though a formal agreement had already been executed elsewhere. No corrective action appears in public files. No challenge is recorded. The letter's language, though privately held, appears to substitute for the missing public record. What makes this discovery particularly difficult to dismiss is where it does not appear. There is no duplicate of the letter in the New York County Clerk's office. There is no cross-reference in the Registry of Deeds. No index card points to its existence. The public system remains silent, while the private document carries operative weight. This is not a lost contract rediscovered. It is a document that should never have been sufficient, yet seems to have been treated as such. The date matters. In 1908, the aftershocks of the previous year's financial panic were still reshaping institutional behavior. Stability was prized, and disputes that threatened confidence were avoided. A letter that allowed continuity without reopening questions would have served a practical function, even if it lacked formal authority. That practical role, however, does not explain its survival outside the channels that normally preserve consequential agreements. The act of donation adds another layer. When the private correspondence was transferred to the archive decades later, it underwent a process of selection and description. The letter was not discarded, nor was it isolated as an anomaly. It was retained, labeled, and made accessible as historical material. The action of preservation transformed it from a private convenience into a public artifact without ever granting it legal status. The consequence extends beyond historiography. Because the letter survived where the formal record did not, it now stands as the earliest surviving articulation of control over the lot. It anchors a sequence of decisions that would otherwise appear arbitrary. It does not prove intent, but it documents effect. It shows that obligations were acknowledged and acted upon, even if never formally ratified. There is no evidence within the document itself that it was meant to replace a contract. There is also no evidence that a contract ever followed. The letter occupies a space that should be empty. Its existence is the discovery, not its explanation. It introduces an element that the public system denies, while the private record confirms. The reflective question that emerges is unavoidable but restrained. When a privately preserved document carries more operational weight than a public registry, which one defines reality? The block concludes not with an answer but with an image. The letter rests today in an acid-free folder, its edges softened by age, its date still legible, its language intact. It sits among personal papers, catalogued and quiet, while the next step of the investigation moves away from what was found and toward why such a document could function at all without ever becoming official. Between 1899 and 1910, the risk that surrounded documentation in New York's elite circles was not abstract or hypothetical. It was procedural, reputational, and increasingly visible. This was the period in which wealth became legible in new ways, and legibility itself turned into a liability. The Surrogates Court of New York County sat at the center of this tension, not as a theatrical arena of scandal, but as a quiet processing chamber where inventories, valuations, and succession claims converted private fortunes into public knowledge. The danger lay in what happened once paper entered that system. An inventory filed with the court was not merely a list of assets, it was an assertion of truth under scrutiny. It invited examination by heirs, rivals, tax authorities, and, most unpredictably, the press. By the first decade of the 20th century, New York newspapers had learned that probate filings were a reliable window into the real architecture of wealth. They did not need criminal wrongdoing to generate headlines. Discrepancies, unexplained transfers, or sudden changes in control were enough to fuel columns that questioned judgment, ethics, or family stability. Within this environment, elites adapted. The action that matters here is not a single transaction, but a behavioral shift. Assets and arrangements were increasingly handled in ways that minimized the production of formal, discoverable records. Verbal understandings, letters of instruction, and informal correspondence allowed parties to coordinate outcomes while avoiding triggers that would force disclosure. This was not lawlessness, it was risk management, calibrated to a system that punished exposure more harshly than ambiguity. The Surrogates Court provided a clear example of why caution was rational. Once an estate entered probate, the valuation of property could be challenged. If a parcel appeared to have changed hands informally, questions followed. When did control shift? Under what authority? And why was no deed recorded? Each question carried financial consequences. Taxes could be reassessed. Heirs could dispute distributions. Even if the outcome remained unchanged, the process itself created a paper trail that persisted indefinitely. Reputation amplified the stakes. Social standing in this era depended on the appearance of order. A family whose affairs were described as unclear or unusual risked being framed as careless or worse, manipulative. Newspapers did not need to accuse, they only needed to quote filings. An administrative irregularity could linger in public memory long after courts had moved on. For families whose names were attached to buildings, institutions, and philanthropy, such attention undermined carefully constructed legacies. Correspondence offered an alternative. Letters could articulate expectations, obligations, and timelines without invoking the machinery of registration. They could be retained privately, shown selectively, or withheld entirely. In certain legal contexts, particularly those involving good faith arrangements between known parties, such correspondence could later be referenced as evidence of intent without ever having been designed for that role. The key advantage was control. Who saw the document, when, and under what framing? The concrete action embedded in this context is omission. Records that would normally have been filed were deliberately not produced. Deeds were not executed. Contracts were not submitted. Instead, outcomes were stabilized through conduct, use, management, and acknowledgement, rather than documentation. The system tolerated this to a degree because challenging it required someone to initiate exposure. As long as no party stood to gain more from dispute than from silence, the arrangement held. The consequence was paradoxical, but real. Over-documentation became a threat. A meticulously recorded agreement could generate vulnerabilities that an informal understanding avoided. Once written, indexed, and archived, a document could not be reshaped or forgotten. It could be cited decades later, stripped of context, and used to challenge descendants who had no role in its creation. Silence, by contrast, aged more safely. This explains why, in the window from 1899 to 1910, the absence of paper does not necessarily indicate the absence of action. It often indicates the opposite, deliberate restraint. Decisions were made with full awareness of their effects, but with equal awareness of what formalization would cost. The legal system did not require constant documentation to function. It required only that disputes remain dormant. The risk extended beyond courts. Financial markets were watching. Banks, insurers, and investors paid attention to reputational signals. A family entangled in public succession disputes could find credit tightened or partnerships reconsidered. Again, no crime was necessary. Uncertainty alone was enough to alter terms. In that climate, the safest transaction was often the one that left the least trace. The consequence of this culture is visible in the record gaps themselves. Files that appear incomplete are not necessarily the result of loss or neglect. They may reflect a period in which incompleteness was the objective. The system absorbed these absences and continued to operate, normalizing arrangements that rested on mutual understanding rather than explicit proof. The tension resolves, for now, in a simple image. A probate ledger from the era, bound and orderly, lists values and names with precision, yet the mechanisms that produce those numbers remain partially unseen. The next step in the investigation moves from why paper was avoided to identifying the moment when avoidance required a specific administrative choice to be made. In the autumn of 1907, when Manhattan's property market was still recalibrating from the shock of the panic earlier that year, the question of whether to formalize the lot's transfer did not remain theoretical. It reached a point where someone had to decide, in plain administrative terms, whether the agreement would be made visible to the public system or kept within the controlled boundaries of private proof. The date matters because the climate mattered. October 1907 had become a reference point for instability, and by late November, the city's legal and financial circles were operating with a new sensitivity to anything that could trigger scrutiny. The entity that surfaces in surviving traces is a plausible but deliberately understated legal office. Harrington and Blythe, attorneys at law, a firm name that appears in related correspondence headers and billing notations, and a trust office that handled long-term holdings in a manner consistent with elite practice. The action in this block is concrete and narrow. A private meeting is convened and a recommendation is recorded explicitly to not execute a formal contract that would require filing, indexing, or later disclosure. The decision is not framed as evasion, it is framed as governance. The meeting itself is not described in grand language in any surviving text because meetings like this rarely were. The traces appear indirectly, a dated appointment entry, a brief letter instructing preparation of alternative confirmations, and a notation on a fee ledger that distinguishes between a draft instrument and correspondence confirmation. It is in these small administrative distinctions that the moment becomes legible. A formal instrument was contemplated, drafting began, and then drafting stopped. The person with the authority to decide is equally consistent with the period's institutional reality. The power did not sit with a junior attorney or a clerk. It sat with the figure who could bind the family's long-term posture. In the surviving pattern, that authority looks like a trustee acting under a family trust arrangement, coupled with a principal, an older patriarch or a designated representative whose approval was required for any act that could alter the public footprint of the estate. The language used in the relevant notes is not emotional, it is functional, avoid record, retain flexibility, confirm by letter, witnessed understanding sufficient for present operations. This is the shift that matters. Until that point, the absence of a deed could be explained away as delay, oversight, or the normal friction of paperwork. After this moment, the absence becomes intentional. A formal contract is no longer treated as the solution to uncertainty. It is treated as a liability that would convert a manageable arrangement into a discoverable one. The recommendation is not to leave the matter unresolved, but to resolve it differently, through a series of confirmations that create enforceable social and practical obligations without creating a single instrument that can be indexed in a courthouse. The reasoning is structurally tied to the context already established. Filing creates permanence. Permanence creates exposure. Exposure invites questions that do not remain confined to the transaction. A recorded contract would force a narrative into the public domain. Who agreed, when, under what consideration, and why the lot's control was changing at a moment when markets were unstable and family reputations were fragile. Even a perfectly legal agreement could become an entry point for criticism. It could be read alongside probate disputes in surrogate's court, compared against tax valuations, and quoted without nuance in the press. The administrative cost of clarity could exceed the operational benefit of having a deed on file. So the meeting produces a practical alternative. Instead of a single executed contract, the file begins to favor understanding confirmed by letters and, where necessary, by trusted witnesses, language that can be invoked later without requiring the public ritual of execution. The action is not passive. It requires work. It requires drafting letters that carry the weight of obligation, aligning their terms with standard legal phrasing, and ensuring that key parties hold copies in controlled custody. It requires the trust office to proceed with management as though the transfer is settled, and for counsel to maintain a private chain of proof that can be produced selectively if challenged. The consequence is immediate and long-lived. Once the formal instrument is abandoned as a strategy, the system around the lot adapts. Administrative behavior begins to treat the absence as normal. The trust office can manage and authorize use without referencing a recorded deed. Tax matters can proceed on the assumption of control rather than title, because the city's priority is collectability and consistency, not narrative purity. And future decision-makers inherit a posture. The correct way to handle this asset is not to fix the missing document, but to operate as though the missing document is beside the point. This is where the internal decision becomes an institutional one. The absence of a contract is no longer an accident to be corrected by a later clerk or a more diligent lawyer. It becomes a deliberate boundary around what will be allowed to exist publicly. The gap is curated. The record is shaped not by what is written, but by what is withheld from the systems that preserve and expose. The decision also narrows who can speak with authority. If a deed had been recorded, any future party could point to it and argue from it. Without it, authority becomes more centralized. The family's trustee, council, and selected representatives control the narrative by controlling the evidence. That is not a dramatic revelation. It is an administrative one. It is governance through custody. The tension is resolved only in the limited sense that the path is chosen. A contract is drafted and then intentionally not executed. Letters become the operative instrument. Witnessed understandings replace filed certainty. The investigation advances because it identifies the moment the system stopped aiming for formal clarity and started aiming for controlled survivability. The block ends with an image that is both ordinary and decisive. A folder in a private legal archive marked "Draft, Do Not File," containing an unfinished contract with blank signature lines, followed by a neat stack of outgoing letters on Harrington and Blythe letterhead. Each dated, each precise, each capable of functioning as proof without ever becoming a public record. In March 1911, the lot stopped being a story that needed explaining and became a category that no longer invited questions. That change did not happen in a courtroom, and it did not require a new deed. It happened inside the machinery that New York used to describe property for taxation and administration through the Municipal Board of Assessors, operating in the same institutional orbit that would later be formalized under what New Yorkers now recognize as the city's finance structure. The action in the record is specific. The parcel is reclassified, and the reclassification is written in a technical vocabulary that reduces the need for the kind of public documentation people instinctively look for. In the surviving assessment materials from that year, the lot's description shifts away from language that implies a clean transfer between private owners and toward language that implies function. Not sold, not conveyed, not granted. Instead, a term that behaves like infrastructure, an easement reference, a right-of-way notation, or what clerks sometimes treated as a service parcel, land administered for access, utility, or operational necessity rather than for ordinary private exchange. It is a bureaucratic move that sounds neutral and procedural. That is precisely why it works. A parcel described as a functional exception doesn't demand the same narrative as a parcel described as a family asset moving through contracts. What changes in the real world is not the lot's physical boundaries, but its administrative identity. The index route shifts, the cross-references change, The parcel is no longer expected to carry a straightforward chain of ownership in the portion of the system that most outsiders rely on. In the assessment roles, the parcel's entry begins to point sideways rather than backward. The prior line that would normally direct a clerk to a deed book reference is replaced by a shorter technical note. A classification code stands where a narrative should be. The record is not erased. It is repackaged into a form that looks complete to the system while remaining incomplete to anyone searching for a conventional transfer. This is how editing can occur without looking edited. There is no dramatic strike-through. There is no missing page that signals theft. Instead, the appearance of order is preserved by moving the parcel into a ledger category where absence is expected. Once that happens, the missing contract becomes less conspicuous because the system itself no longer treats a contract as the primary source of truth. It treats classification as truth. It treats administrative designation as reality. The act of reclassification also changes which office becomes the gatekeeper of meaning. A deed sits in a public archive and invites ordinary interpretation. A technical classification sits behind a counter and requires institutional fluency. The questions that would naturally follow, why no deed, why no executed agreement, why the parcel behaves as if it changed hands, can now be deflected with procedural language. The parcel is assessed under service designation. The parcel is subject to easement conditions. The parcel is administered under a right-of-way reference. Each phrase functions like a polite barrier. It does not deny anything. It simply makes the next question harder to ask in a way that forces an answer. The surviving traces show that the lot's description becomes narrower in one sense and broader in another. Narrower because the entry stops telling a story. Broader because the entry now belongs to a category that can incorporate many kinds of arrangements without distinguishing between them. A private understanding can live comfortably inside a functional designation because function does not require the same proof as ownership. A parcel can be treated as controlled, restricted, or allocated without forcing the public system to identify the instrument that created that control. In practice, it allows a private architecture of obligations to operate under a public label that sounds administrative rather than negotiated. The immediate consequence is institutional insulation. Once the lot is processed as an administrative exception, it is shielded from the most common lines of inquiry. The casual researcher who searches for a deed trail meets a dead end that looks routine rather than suspicious. The official who needs to reconcile assessments can accept the designation without reopening origins. The tax apparatus cares about collectability and consistency, not about reconstructing a narrative that predates the current ledger logic. In other words, the lot becomes easier to manage precisely because it becomes harder to interpret. This shift also affects indexing. In earlier years, the parcel's identity would have been anchored in a straightforward block and lot story, a name, an entry, a reference, a path back through recorded instruments. By 1911, the path begins to loop through technical files, map plates, and cross-references that do not behave like ordinary title records. It is still there, but it is there in a way that changes what there means. The record now points to a classification that implies entitlement without requiring the clerk to prove transfer. One can see the subtlety in the way the lot's description is compressed. Where earlier entries might have included fuller location language and clearer relational notes, the 1911 materials favor shorthand that only insiders can decode. A partial lot notation can appear. A reference to a map plate rather than a deed book can replace older style citations. A phrase that sounds like internal housekeeping subject to service use, held for access, easement recorded separately, can substitute for the missing narrative. The record remains coherent within the system because the system is built to accept this kind of shorthand. But it becomes incoherent to anyone who expects the public record to explain itself. This is not a flamboyant act. It is a quiet one. It does not require a conspiracy in the cinematic sense. It requires only that the right people understand what the classification accomplishes. A trust office can continue administering the lot as though the underlying understanding is settled. Council can maintain private correspondence as the functional backbone. The municipal apparatus can treat the parcel as a technical object, assessed and controlled through designation rather than through story. Each component reinforces the others without any single component needing to disclose the whole. The consequence reaches forward. Once the lot exists as an administrative exception, later decisions, fiscal, operational, even succession-related, inherit the exception as if it were normal. A future clerk does not see a mystery, they see a category. A future heir does not see an unresolved transfer, they see a parcel that functions under a designation. And because the designation is expressed in institutional language, challenging it would require reopening not just a missing contract, but the administrative logic that replaced it. The absence becomes sticky. It becomes defended by procedure. There is a restrained question that sits at the edge of this change, and it is the one the record's design almost dares you to ask. What is easier to hide, a document, or the way a system chooses to catalogue what a document would have proven? By late 1911, the lot is no longer merely operating under an understanding that survived in private letters. It is operating under a public classification that makes the absence of a formal contract less visible because the ledger no longer expects that contract to exist in the form outsiders would recognize. The case has been edited, but the edit is performed through indexing and description, not through deletion. The block ends on something you can picture without embellishment. A tax map plate from 1911, its printed lines clean, a small stamped date in the margin, and a neat handwritten notation beside the parcel's outline, technical, brief and sufficient, where a longer explanation would have once belonged. The tension that remains is practical and immediate. If the record was shifted into a category that deflects ordinary questions, the next question is not whether the change happened, but who requested it, and who gained the most from the lot becoming an exception rather than a transaction. By 1912, the effects of silence were no longer abstract. They had condensed into advantage. The lot's ambiguous status, once a temporary accommodation, now produced a clear beneficiary, a small, insulated nexus of control centered on Hudson Meridian Trust and an estate manager whose authority expanded precisely because the paper trail had narrowed. The date matters because the posture had stabilized. What had been experimental between 1907 and 1911 became operational policy in 1912, and the system around the parcel adjusted accordingly. The action in this block is consolidation, not a sale, not a conveyance, but a tightening of practical authority. Management rights, access permissions, and operational decisions begin to flow through a single channel, administered by the trust and executed by a named estate manager, Edwin L. Harper, whose correspondence appears with increasing frequency in administrative exchanges. Harper does not claim ownership. He does not need to. His authority derives from continuity. He is the one who signs instructions, authorizes use, and interfaces with municipal offices that now recognize the parcel as a functional exception rather than a tradable asset. This shift produces a measurable change in how the property appears in estate planning, where a formally documented asset would demand explicit treatment in inventories. Valuation, description, lineage. The lot's classification allows it to recede. It is present, but not prominent. It does not invite appraisal in the same way. It is not framed as a discrete inheritance problem. Instead, it sits within a managed envelope, controlled by the trust's internal accounting rather than exposed to the enumerative rituals of probate. The absence of a contract does not weaken control. It strengthens it by reducing the number of parties who can plausibly claim standing. The mechanism is subtle but decisive. A third party seeking to contest control would need to identify a document to contest. With no executed deed to attack, no contract to interpret, and no filing to challenge, the path to dispute becomes steep. The administrative record confirms function without revealing origin. The trust's position is therefore defensive by design. It does not assert more than it needs to. It asserts enough to operate, collect, authorize, and deny. The beneficiary is not a single person in the dramatic sense. It is a configuration. The trust, the designated manager, and the principal interests whose names do not need to appear on public ledgers. This configuration gains leverage in three ways. First, by reducing exposure in inventories, it limits what can be discovered by heirs who were not part of the original understanding. Second, by centralizing decision-making, it prevents fragmentation of authority that could invite scrutiny. Third, by decoupling the lot from open disputes, it keeps the parcel out of adversarial forums where silence would be questioned rather than accepted. The practical effects are visible in how the parcel is accessed. Requests for use or modification route through Harper's office, not through a family member whose authority could be challenged. Correspondence from 1912 onward shows a consistent pattern: approvals granted, conditions imposed, and fees assessed. Without reference to ownership, the language is managerial. It assumes control as a given. This is not secrecy as concealment. It is secrecy as routine. There is a financial consequence as well. By avoiding formal transfer, the trust mitigates the risk of revaluation triggered by sale or conveyance. Tax exposure remains stable. The parcel's assessed function supports predictable treatment. Stability is itself an asset, particularly in a period when public scrutiny of wealth remained intense. The trust's leverage lies in making the lot boring to the system that would otherwise dissect it. The estate manager's role illustrates the advantage clearly. Harper's name appears where a deed would normally speak. He becomes the human interface that absorbs questions and provides answers calibrated to the classification. When asked why a particular permission exists, he points to administrative designation. When asked who authorizes access, he produces correspondence. When asked about ownership, the question dissolves into function. Each response is accurate within the system as it has been shaped. None of them require revealing a document that does not exist. The consequence for potential challengers is deterrence. Without a contract to contest, there is no obvious entry point for litigation. Without litigation, there is no discovery. Without discovery, there is no expansion of the record. The trust's leverage is therefore negative space, the power of what is not there. Silence in detail. This configuration is not neutral, it is protective. This does not mean the arrangement is invisible. It means it is legible only to those who already understand the institutional language. To an insider, the pattern reads as control. To an outsider, it reads as administration. That asymmetry is the benefit. It allows the trust to manage the parcel with confidence while keeping the number of informed observers small. The social consequence follows. Families whose interests align with the trust's management avoid the reputational cost of visible maneuvering. There are no headlines about contested transfers, no columnists speculate about unusual deeds. The lot does its work quietly, and the trust accrues credibility as a stabilizing steward rather than a litigant. That credibility feeds back into leverage, reinforcing the trust's position in future negotiations unrelated to the parcel itself. By the end of 1912, the beneficiary of the silence is clear in operational terms. Control has been consolidated into a structure that does not need public affirmation to function. The absence of a contract has not weakened authority, it has redistributed it to those best positioned to operate without explanation. The block closes on a concrete image that captures the advantage. In a trust office ledger dated December 1912, a single line records management fees associated with the parcel. No deed reference, no owner named, just an account number and an initial. The entry is ordinary. The power it represents is not. The next step in the investigation turns from who benefited to what vanished as a result, because consolidation always leaves something behind, even when the record pretends nothing is missing. In 1916, the case stopped being defined by what had never been filed and became defined by something more concrete, what should have been in the file and was no longer there. Up to that point, the absence of an executed deed could be defended, at least administratively, as an intentional posture, a choice to operate through letters, classifications, and managed authority. But 1916 introduces a different category of absence, one that cannot be explained by preference alone. It is the year when the expected attachments, the ordinary mechanical pieces that accompany a functioning administrative exception, fail to appear where the system itself says they belong. The trail leads into two places that rarely attract attention until something goes missing: the city archives and the county clerk index division. Both are designed to make records retrievable, not meaningful. They preserve the ability to locate, not the obligation to understand. That distinction matters because the disappearance in this block is not theatrical, it is procedural. It is a void that sits inside an otherwise orderly apparatus, shaped to look like routine incompleteness. The action begins with a request. A clerk in the index division is asked to pull the parcel's packet, an expected set of materials that would normally include the cross-referenced annexes. A draft instrument if one existed, a receipt of transfer if one had been tendered, a protocol number if any filing attempt occurred, and, in cases involving reclassification, a map attachment or plate reference that translates a lot into a technical category. The request is not extraordinary. By 1916, this kind of retrieval happens quietly, the way the city confirms details when departments need consistency across books. The packet is pulled, and what appears is not a scandal, but a jacket, a thin file wrapper, a stub that signals completeness without providing it. The wrapper carries the kind of internal handwriting that suggests the file once had more structure. A penciled C annex, a notation for XH, with a letter that implies multiple exhibits, and staple holes along the upper corner where an envelope or addendum would typically be fastened. The record is physically marked as having held attachments. That is the first hard fact of disappearance. The file carries the scars of contents that are no longer present. What should be there is not speculative. Administrative practice leaves predictable footprints. If a parcel is reclassified into something like a service designation or right-of-way condition, the supporting material is rarely narrative, but it is almost always documentary in the narrowest sense. A map excerpt, a technical description, a routing memo, or an internal receipt showing which office accepted responsibility for the change. In this file, the notations point to those supports, yet the supports are absent. There is no annex envelope, no folded map, no plate image, no routing sheet with a protocol stamp. The jacket remains, and the contents do not. The disappearance is also visible in the indexing itself. The County Clerk Index Division relies on reference integrity. An index card that sends a clerk to a specific folder number is supposed to terminate in a folder with that number. Here, the reference is incomplete in a way that is not simply lost to time. A partial folder designation is present, but the final digits are missing, overwritten, or never transferred into the newer indexing format. The system still points, but it points with a blunted finger. A researcher can follow the path to the drawer, but not to a definitive endpoint. That, too, is a concrete absence. A reference number that should anchor retrieval no longer exists in full. Other expected material is missing in a quieter way. Property files in the early 20th century sometimes carried photographs, not glamorous portraits, but functional images, particularly when a parcel's use or access was being documented for municipal purposes. In this case, the file notations suggest that a visual reference once existed, not because anyone wanted an aesthetic record, but because a visual plate makes an exception legible. Yet by 1916, there is no photograph in the packet, no mounting corners, no caption sheet. There is only a faint imprint on the inside of the jacket, the kind left when paper has been pressed against paper for years. It is not proof of what the missing item depicted, but it is proof that something used to be stored there. The disappearance does not end at attachments. It reaches into names. Earlier traces, the ones implied by the trust's internal accounting and the estate manager's correspondence, suggest that the parcel once carried a more explicit nominal reference in certain contexts, if not in public title language, then in internal descriptions that identified the asset as tied to a particular holding structure. By 1916, those nominal anchors are thinner. The file jacket uses functional labeling, not a family identifier. The index cards emphasize category and location rather than association. The parcel is still administratively present, but the parts of the record that would connect it to a specific lineage are reduced or absent, not through a visible strike-through, but through omission. This is what disappearance looks like inside an institution that values continuity over explanation. Nothing announces that items have been removed. There is no red stamp reading missing. There is no disciplinary notation. The file simply arrives at a moment when it is needed and fails to contain what the system's own handwriting implies should exist. The absence is not recorded as an error because the system is built to tolerate incompleteness, especially once a parcel has been normalized into an exception category. The city can still tax. Offices can still reference the designation. The trust can still manage. The machine can continue without the missing pieces. And that continuity prevents the absence from being treated as a problem. The consequence is structural. Any later audit, whether internal, municipal, or private, encounters a gap that has been made ordinary. There is no single missing deed that would trigger the classic question, where is the instrument? Instead, the auditor meets a file that appears to contain what the file is now expected to contain: a classification identity, a technical posture, and a chain of administrative acceptance. The missing annexes are invisible to anyone who doesn't know to look for staple holes, incomplete reference numbers, or the faint logic of how such packets were assembled. The void does not present itself as a contradiction. It presents itself as a thinness that the system has learned to accept. And that is why the disappearance in 1916 matters more than earlier absences. Earlier, the record could plausibly claim it never created a paper trail. Here, the record shows it once had one. The jacket implies a fuller file existed. The index implies a destination existed. The administrative vocabulary implies supporting attachments existed. In 1916, those supports do not merely fail to appear publicly, they fail to appear internally, where they would normally survive even when a deed does not. There is no need at this stage to assign motive. The only claim this block makes is the measurable one. Expected components are absent from the places designed to retain them. The City Archives holds the jacket without the annexes. The County Clerk Index Division holds references without stable endpoints. What left to exist is not just a document, but the connective tissue that makes an exception legible, the folder number that completes retrieval, the map, plate that explains classification, the receipt that anchors routing, the visual reference that confirms function, and the nominal traces that would tie the parcel to a specific human architecture of authority. The tension resolves in a way that is almost bureaucratically cruel. The system does not collapse when something vanishes. It continues. It taxes and indexes and defers. That continuation becomes the mechanism by which absence becomes safe, because safe absences do not provoke restoration. They provoke accommodation. The block ends with a concrete image that can be held in the mind without embellishment. A manila jacket on a City Archives table, its pencil note reading "See Annex," 2 empty staple holes at the corner, and an index card from the County Clerk Index Division beside it, typed, orderly, and incomplete by a few digits, as if the file was designed to be found while ensuring the missing piece could never be retrieved. The next step is unavoidable and narrow. When a system points to attachments that no longer exist, the only way forward is to identify where the references still disagree with one another and where the record, despite its careful thinness, fails to stay consistent. In 1923, the first thing that fails is not the narrative, it's the arithmetic. The parcel that had been managed as an administrative exception since 1911 and kept deliberately thin in public record-keeping appears indirectly inside a proceeding that does not tolerate vagueness the way municipal ledgers can, a probate inventory in the surrogate's court of New York County. It is not described as a deeded lot. It is not even described in a way that would allow a casual reader to map it cleanly. But it is there, embedded in the language of an estate schedule that assumes the parcel exists, assumes it carries value, and assumes someone had the authority to treat it as part of a patrimonial structure. The case file is plausible in the way most surrogates court. Matters were a decedent with Manhattan exposure, a trust arrangement administered by Hudson Meridian Trust, and a set of schedules listing personal property, securities, and real property interests in forms that look standardized until you read them closely. The action that matters is concrete. A valuation entry is submitted to the court, and that valuation presupposes the lot's inclusion while failing to describe it correctly. The inventory doesn't say the mysterious parcel. It does what probate documents do. It tries to be precise, and in trying to be precise, it reveals an inconsistency that shouldn't be possible if the underlying chain were clean. The line is not dramatic. It is the kind of line most clerks would scan and accept unless a dispute forced attention. A real property interest is listed with a shorthand location reference, enough to indicate Manhattan, enough to suggest proximity to the corridor that had shifted toward higher-end offices and residences, but not enough to identify a block and lot in the normal way. The description leans on functional language, consistent with the 1911 reclassification posture, something like service parcel interest or right-of-way condition, paired with a value that pretends to be precise. And then the number appears. The number doesn't match the neighborhood's logic. It is either too low to be credible for a Manhattan parcel with practical leverage, or too high to be credible for a mere administrative easement. Depending on how you read the shorthand, the figure sits in the wrong register. It is not the valuation you would expect for an ordinary sale, and it is not the valuation you would expect for a minor access designation. It looks like a compromise number, an internally meaningful value presented externally as though it were objective. That is the first inconsistency, a valuation that behaves like a private accounting decision forced into a public template. The second inconsistency is spatial. The SATI schedule includes a rough area reference, an approximate frontage or a square foot estimate that cannot be reconciled with what the municipal maps had already stabilized by 1911. The figure suggests boundaries that either exceed the functional parcel's outline or shrink it in a way that would make the later administrative designation nonsensical. It is not a rounding error. It is a mismatch of shape. The probate inventory is describing a thing that exists, but it is describing it as though the clerk were working from an internal description that never fully translated into public cartographic terms. The third inconsistency is temporal, and it is the one that should not appear at all if the silent arrangement had been merely an administrative convenience. In a brief phrase, so brief it could be overlooked, the inventory references the start of possession or control as preceding the period in which the lot's behavior first became visible in the county clerk's indexing logic. The date is not framed as a deed date. It is framed as practical control, the kind of language used when a party needs to assert continuity without producing a conveyance. The inventory suggests control in a year that sits earlier than the 1907 inflection point that triggered the entire posture shift, not earlier by months. Earlier enough to imply that the operational agreement may have been functioning before the public record began reflecting it. This is not a minor inconsistency because probate is not meant to invent dates. Probate is meant to record the estate's claims in a way that can be relied upon by heirs and the court. A possession date that slides backward is not merely a sloppy annotation. It is either a defensive maneuver, an attempt to anchor control in a period less likely to be questioned, or it is a leak from an internal chronology that the public systems were never supposed to capture. Either way, it introduces a tension the record has been designed to avoid, a timeline that implies practical transfer without formal transfer, and now the court is being asked to accept it. The fourth inconsistency is in the signatures. On the schedule page, where you would normally expect an executor, trustee, or authorized representative to sign in the designated line, the signature that appears is displaced. It is positioned as if it belongs to a witness line or an attestation rather than the party asserting the claim. The name is not the trust company itself. It is not the estate manager's formal title. It reads like an intermediary, someone who can affirm facts without being the legal actor who created them. The placement suggests caution. The estate wants the statement made, but wants the responsibility softened through form. That signature placement matters because it mirrors the strategy already visible in earlier years. Letters functioning like contracts, witnesses functioning like instruments, administrative categories functioning like title logic. Probate does not like this ambiguity, but probate can be forced to tolerate it if no one challenges it. If an heir contests the schedule, the displaced signature becomes a problem. If no one contests it, the schedule becomes another quiet brick in the wall, accepted as routine. The fifth inconsistency is what the schedule does not include. In 1923, if the parcel were truly a standard deeded asset, you would expect a clean reference to recorded instruments, book and page, block and lot, or at minimum, a stable cross-reference that a clerk could verify without interpretation. Instead, the inventory relies on the same thinness that has protected the parcel since 1911. Functional wording, approximate identifiers, values that behave like internal decisions, and the absence of attachments that could stabilize meaning. It is as though the court is being asked to accept the parcel's existence in the same way the municipal apparatus had, by treating classification and continuity as sufficient, even when underlying proofs remain unproduced. The consequence is not speculative. It changes what later auditors and litigants can do. A probate filing becomes a point of anchoring. Once a court file contains a value and a claimed continuity of control, the estate has effectively inserted the parcel into a legal ecosystem that can later be cited as precedent of practice. Not a deed, not a contract, a judicially housed artifact of acknowledgement. That can be powerful in its own way because it shifts the question from where is the instrument to why did the court accept the schedule? And courts, once they accept something uncontested, become reluctant to reopen it without a triggering dispute. At the same time, the inconsistency limits that power. Because the value, boundaries, and date do not align cleanly with municipal descriptions, the probate entry cannot function as a clean substitute for the missing contract. It proves too much and too little at once. It implies the agreement existed in practice and was recognized by the people managing the estate, yet it preserves the pattern of incompleteness that has followed the parcel since 1907. It is evidence that arrives already damaged, precise enough to matter, imprecise enough to avoid closing the file. That is the structural signature of the entire case. When proof appears, it appears with the edges trimmed. A number is offered, but it sits in the wrong range. A boundary is hinted, but it cannot be reconciled with the administrative map. A possession date is asserted, but it slides backward past the moment the public system began to reflect change. A signature is present, but it is placed where responsibility is diluted. The file does not collapse under these inconsistencies. It absorbs them, because each inconsistency is tolerable on its own. Together, they indicate something more deliberate, a practiced ability to acknowledge reality without formalizing it. The reflective question that follows is narrow, and it is difficult to avoid. When the proof finally surfaces in a court file, why does it arrive already incomplete? By the end of the 1923 proceeding, the inventory remains on record. The surrogate's court does what it is designed to do when no one forces a confrontation. It accepts the schedule, stamps it, and allows the estate to proceed. That acceptance does not resolve the parcel's origins. It does something subtler. It creates an official place where the parcel is treated as real while still being described in a way that prevents ordinary verification. The inconsistency becomes part of the institutional footprint. The block closes on a concrete image, a single page in a probate packet, filed in 1923, the court stamp slightly blurred at the top margin, a typed line describing a service parcel interest in Manhattan, a valuation figure that sits uneasily against the surrounding entries, and a signature that appears one line lower than it should, aligned with a witness. Attestation rather than the claimant's declaration. The tension that remains is resolved only in direction. If the court could accept an entry that doesn't match its own logic, then the next question is, what would happen if the mismatch were forced into daylight? And who, in 1923, had the most to lose if someone did? By the time New York entered the post-war years, the lot silence was no longer just a private convenience. It had become a structural risk that could spill outward the moment the city's routines intersected with the parcel's carefully engineered thinness. On April 14, 1920, as Manhattan departments reconciled older assessment categories with newer corridor planning and map revisions, the city was building a paper world fast enough that older, thinner files began to look less like quirks and more like liabilities. The named pressure point in this period is the City Planning Commission, not as a villain and not as a conspirator, but as an institution whose work depends on clarity that can survive challenge. Planning staff did not care who felt embarrassed. They cared whether a line on a map could be enforced, whether a right-of-way notation could withstand objection, and whether a service classification would hold if it entered a public process. When the commission reviewed a corridor, it pulled plates, compared descriptions, and asked for the kind of stabilizing proof an administrative exception can usually avoid, until the exception becomes the obstacle. Between 1919 and 1921, the most realistic ignition was never a dramatic whistleblower. It was a discrepancy the city had to resolve as it modernized. If a technical classification sits on a parcel that behaves economically like prime private land, it becomes an anomaly worth flagging, not because someone suspects a crime, but because the anomaly can sabotage the city's own consistency. A single misfit category can complicate assessments, street alignments, utility routing, and the logic of who may access what and on what authority. The action in this block is mundane, and that is exactly why it matters. A routing slip is generated for classification reconciliation. A staff note requests confirmation of the parcel's basis. The finance side that carries the designation is asked to produce the supporting reference that normally stabilizes the description. The County Clerk Index Division is asked for the anchor number that would allow retrieval without interpretation. City Archives is asked for the annexes that typically travel with technical reclassifications, a map excerpt, a routing memo, an internal receipt showing which office accepted responsibility for the designation. And what made the situation dangerous is that every one of those requests could be satisfied without controversy until it encountered the place where the file had been thinned on purpose. If the mismatch surfaced openly in 1920, the first consequence would have been fiscal. A parcel treated as function could be re-evaluated as asset. Re-evaluation invites retroactive questions: how long, under what authority, and why the classification diverged from market reality. That does not require criminal allegations to become damaging. It only requires an auditor to document inconsistency. Once documented, the city can revisit assessments, recalculate obligations, and issue notices that force a response from whoever is positioned as the party in control. The second consequence would have been adversarial. The moment a public inquiry exists, dormant private disputes wake up. Heirs who had accepted quiet management could suddenly see an opening. If the parcel's basis is questioned, then control can be questioned. And if control can be questioned, distribution can be questioned. Surrogate's court might not be the trigger, but it becomes the arena where fallout lands, because probate disputes thrive on ambiguity that can be reframed as impropriety. Even if every act had been technically defensible, the cost of defending it publicly could be ruinous, because defense requires documents, and documents create trails. The third consequence would have been reputational and networked. A trust company like Hudson Meridian Trust did not operate in isolation. It sat inside a web of banks, counsel, title examiners, insurers, and public-facing donors whose names mattered because they signaled competence. If a single parcel became a public story about missing instruments and classification, substituting for title, the story would not remain about the parcel. It would become a question about governance: who authorized the posture, who relied on it, and who benefited from the city treating an exception as normal. The press is part of the risk, even when it reports nothing specific. In 1920 and 1921, a major paper like the New York Times did not need to accuse anyone to cause damage. It only needed to describe a dispute in institutional language and let readers supply meaning. Title: questioned. Assessment under review. Basis unclear. Those phrases read as administrative, but they land socially as judgment. Society columns and business pages turned filings into narratives, and narratives into reputational friction that boards and trustees were forced to manage. Planning questions also invite public process by default. A city planning commission matter can generate notices, minutes, and published summaries. Once those exist, the parcel gains a second life outside private custody. The lot's thin record would be forced into thicker rooms. Committee discussions, council consultations, interdepartmental documentation. The logic that kept it safe, classification over narrative, function over title, would face a system that demands an explanation when maps, assessments, and public hearings converge. This is why the most realistic threat in 1919-1921 is not that the truth would be exposed in one dramatic reveal, but that competing systems would collide and generate paperwork. Paperwork is what the 1907 decision to avoid formalization was meant to prevent. A planning-driven request can force the creation of new documents, clarifying memos, affidavits, and map attachments that translate private understanding into public justification. Those new documents become the very trail earlier council tried to keep from existing, and once created, they can be copied, cited, and weaponized by parties who were never meant to be inside the circle. The incentives to prevent that collision were therefore strong and practical. Keeping the case framed as a technical matter allowed each institution to stay inside its comfort zone. Finance could continue assessing a category without reopening origins. The trust could continue managing without inviting litigants. Council could continue relying on letters and witnessable understandings rather than instruments that could be subpoenaed and reinterpreted. Containment did not require overt concealment. It required a disciplined refusal to let administrative discrepancies become historical questions. The consequence of that containment is simple. The case remains survivable precisely because it is never allowed to become narratable. A story invites characters and blame. A technical matter invites procedure and deferral. When the issue stays technical, alliances stay intact. Banks are not forced into explanations, trustees are not forced into public defense, and associated public figures are not dragged into clarifications that generate headlines. The file can remain thin without collapsing, and the city can keep functioning as if the missing pieces were irrelevant. There is a restrained question under all of this, and it is the one the record keeps answering indirectly. When proof begins to surface, why does it always arrive in a format that prevents a clean public story? The block closes with a concrete scene from the era's paperwork, not a revelation. A 1921 planning map overlay sits on your desk. Inked street lines, a neat legend, and the parcel marked with a small technical notation. Next to it lies a typed inter-office memo, stamped received, recommending that the matter be handled as a classification reconciliation and routed without public hearing. The tension resolves in direction. The next step is to show how that language, repeated, copied, and accepted, turned a risk of scandal into a routine that no one was rewarded for reopening. In 1928, the silence surrounding the lot stopped depending on individual discretion and began to depend on institutional vocabulary. That year is where the case becomes durable, not because anyone finds new proof, but because the offices responsible for safeguarding records learn how to describe a gap without calling it a gap. The mechanism is language, the beneficiary is continuity. and the action, recorded in internal handling notes, is the adoption of terms that turn responsibility into procedure. By the late 1920s, New York's municipal record-keeping was no longer improvisational. It was becoming systematized, with a growing expectation that files would be tracked, moved, and preserved under rules that outlived the people who first created them. That shift created a problem for any case built on selective thinness. A missing annex can look like negligence in a system that expects completeness. A partial reference number can look like error. A jacket with staple holes and no contents can provoke uncomfortable questions. The solution in 1928 was to stop treating the lacuna as a defect and start treating it as a category of custody. The named entities in this phase are not glamorous. They are administrative, a municipal historic preservation office, an office concerned with safeguarding and documenting sites, usage designations, and protected conditions, and a records management unit tasked with controlling access, retention, and movement of sensitive materials. Their interest is not the story of the lot. Their interest is the status of the file. When these entities touch a record, they do not rewrite history directly. They rewrite the conditions under which history can be requested. The action that matters is concrete and replicable. A file status is changed from missing or unlocated to something more defensible, restricted, administrative hold, private record, or maintenance. Each term is small. Each term is vague. Together they create a wall that looks like policy rather than choice. A request that once would have triggered retrieval now triggers a controlled response. The file is not unavailable because it is gone. It is unavailable because it is managed. This is how the language hides responsibility. Restricted does not say who restricted it. Maintenance does not say what is being maintained or why. Preservation implies stewardship rather than withholding. Private record suggests an alternate custody that is legitimate by definition, even if it is never explained. Administrative hold implies that release is possible later, but not now, without specifying what condition must be met or who has the authority to lift it. The terms do not deny the file's existence. They deny the requester's right to context. In earlier years, the case survived by being thin. In 1928, it survives by being procedural. A clerk does not have to decide whether to expose an inconsistency. The clerk only has to follow status. The records management unit becomes the gravitational center of this logic because it controls what access means. Once a file is coded as restricted, the retrieval chain changes. Requests route through supervisors. Logs are created. Reasons are demanded. And the mere presence of those steps discourages the very inquiries that would thicken the record. The most telling shift is how the absence is reframed. The file is no longer treated as incomplete. It is treated as intentionally incomplete to the requester. That difference seems semantic, but it is operational. An incomplete file creates obligation. Locate the annex, reconcile the index, restore integrity. A restricted file creates justification, deny access, cite policy, preserve custody. The problem transforms from where is it to who is authorized, and that is a question institutions can answer without touching the missing pieces. This is also how normalization becomes routine inside a workforce that changes over time. By 1928, staff members who were not present for the 1907 decision, the 1911 reclassification, or the 1916 disappearance inherit a file that behaves like an ordinary restricted matter. They see stamps and status codes, not intent. They learn the language as habit. A new employee does not need to know that an annex should exist. They only need to know that the jacket is under administrative hold and that the correct response is to route the request and close the loop. The consequence is institutional memory without content. The system remembers that something is sensitive, but it does not remember why in a way that can be challenged. The case becomes protected by its own vagueness. The less specific the rationale, the harder it is to contest. A denial grounded in restricted is harder to dispute than a denial grounded in "we can't find it." The first sounds like governance, the second sounds like failure. This is where the secrecy gains its most stable form, not concealment by removal, but concealment by categorization. The file is not lost, only not accessible, and that phrasing changes the emotional temperature of inquiry. A missing deed can provoke outrage. A restricted record provokes resignation. It invites the requester to accept institutional boundaries instead of pursuing contradictions. It also forces time. Time is one of the most effective tools in record control because the longer a file remains restricted, the more normal that restriction feels, and the less likely anyone is to treat it as suspicious. The vocabulary also serves another function. It protects allied institutions. If a file is restricted, no single office has to admit what it lacks. City archives can say the annex is preserved elsewhere. The County Clerk Index Division can say the reference is held under administrative hold. Preservation offices can say they are maintaining sensitive materials. Each office can be technically truthful while collectively ensuring the file never becomes reconstructible. Responsibility dissolves across units, and the very structure of bureaucracy becomes the shield. The consequence is that later inconsistencies, like the 1923 probate number that didn't match the story, can exist without forcing reconciliation. When a system adopts protective vagueness, mismatches become survivable. They are no longer treated as contradictions. They are treated as the natural byproduct of controlled access. The record becomes a puzzle that the institution refuses to let anyone complete, while still insisting the puzzle is being safeguarded. There is a restrained question that emerges from this, and it is the one the vocabulary tries to prevent from being asked. When the file is always preserved but never available, what is preservation actually protecting? By the end of 1928, the case has advanced into its most durable phase. The silence is no longer dependent on a single trustee, a single lawyer's advice, or a single missing annex. It is embedded in procedure. It is maintained by ordinary staff doing ordinary work, routing slips, status codes, response letters, without needing to understand that they are perpetuating a deliberate absence. The secrecy stops feeling like secrecy. It becomes a compliance posture. The block closes on a concrete image that captures the transformation. A request form sits in a records management unit tray, dated 1928, stamped "Restricted Administrative Hold." Beside it is the parcel's file jacket, now marked with a clean status label rather than pencil notes. The folder is not empty in a way that looks like loss. It is empty in a way that looks like policy. The tension resolves into preparation. If silence can be bureaucratized this cleanly, the next step is to see what survives into the modern era and what remains inexplicable even when everything else has been indexed, digitized, and preserved. In 2026, the case does not survive because it is old. It survives because it is interoperable. Its official version is complete. Enough to be accepted by modern systems, yet incomplete in the one place that would allow modern research to close the file. The paradox is that digitization has made most kinds of historical gaps easier to detect, while making this particular gap harder to resolve. because the missing piece is not a missing reference. It is the missing center. The modern attempt begins the way contemporary reconstruction always begins, not with a courthouse visit, but with databases. A researcher starts with what can be searched at scale: map scans, tax rolls, probate indexes, old newspapers, institutional catalogues. They pull the thread using tools that did not exist for prior generations: digitized municipal atlases, searchable proceedings, keyword-indexed social columns, and cross-linked citations buried in scanned pages. Programs associated with large-scale digital libraries, Google Books and comparable library digitization initiatives turn what used to be weeks in a reading room into hours at a desk. That acceleration is real, and it changes the shape of inquiry. The action in this block is equally real and contemporary. The researcher attempts to reconstruct the documentary chain by triangulation. They start with the earliest administrative behavior in 1907. They track the 1908 correspondence that reads like a contract but is not a contract. They overlay the 1911 reclassification language with map plates and assessment categories. They trace the 1916 file jacket logic, where attachments are implied but absent, by comparing index formats across years. They test the 1923 probate anomaly against surrounding valuations. They look for any reference in digitized newspapers that might hint at a public dispute without needing to accuse anyone of wrongdoing. They search for the trust company's name, the estate manager's name, the law office letterhead, and the parcel's functional designation across everything that has been scanned and made searchable. In many cases, this would be enough. Modern research can often rebuild a narrative even when a central document is missing, because the ecosystem of surrounding references becomes dense. But in this case, the surrounding references behave like a deliberately engineered perimeter. They confirm effects, they confirm practice, they confirm that institutions treated control as real, yet they refuse to produce the single instrument that would make control legible in the way modern systems want legibility. A deed book entry, an executed agreement, a recorded protocol number that terminates in a document with signature lines and attachments. The reason modern tools still cannot close the file is not a lack of data. It is the shape of the data that survived. The digitized record is rich in surfaces and thin in interiors. Maps show classification, indexes show routing, ledgers show accounting, probate schedules show valuation, letters show obligations. Each component behaves like a witness statement rather than a confession. They are individually credible and collectively suggestive, but they do not produce the contractual core that would convert suggestion into proof. Digitization also inherits the logic of earlier bureaucratic language. A restricted file from 1928 does not become less restricted because it is scanned. It often becomes more abstract. Modern portals may show that a record exists while withholding it, behind access policies that echo the old vocabulary: restricted, administrative, audacious private record. In a physical archive, a researcher can sometimes read institutional discomfort in a clerk's hesitation, in the friction of pulling a box that hasn't been requested in decades. In a digital environment, the denial is cleaner. A page is simply not there. A catalog entry simply ends. A reference simply points to a placeholder. The old silence gains a new efficiency. The modern researcher can try alternative routes. They can search digitized legal treatises and practice. Manuals for phrasing that matches the 1908 letter, hoping it was quoted or reused. They can search trade publications and real estate circulars preserved in scanned volumes. They can search municipal proceedings for classification code changes, looking for a line item that explains why certain parcels were moved into service categories without traditional documentation. They can pull neighborhood-specific atlases across multiple years and watch the parcel's descriptive language compress. They can use newspaper databases to scan for disputes over easements or right-of-way access that might have touched the corridor. They can query probate abstracts for related estates, looking for the parcel's fingerprint in values that don't match their descriptions. They can even search digitized building permits and utility records where access rights sometimes surface as routine annotations. The pattern does not break. It yields hints without closure. The parcel's administrative existence remains easy to demonstrate. Its legal origin remains hard to prove. And that matters because modern research is not just storytelling, it is evidentiary reconstruction. In 2026, the difference between "we can show the system treated this as real" and "we can prove the instrument that made it real" is the difference between a compelling historical account and a closed file. What still isn't explained is narrow and persistent. Why is there no central contract when the effects behave like contract? Effects. If the lot was stable enough to be taxed, managed, referenced, and inherited, why did the record never contain, or no longer contain, the one document that should have anchored everything? The disappearance of attachments in 1916 suggests something once existed, at least in supporting form. The normalization in 1928 suggests institutions learned how to describe the absence as policy rather than loss. The probate inconsistency in 1923 suggests acknowledgement that could not be made fully explicit, yet none of these elements yields the final piece. The consequence in the present is a legacy that functions without proving itself. The official history is sufficient for administration. The parcel remains categorized and handled in ways that let modern systems continue to process it. Databases accept categories because categories are designed to be processable. But proof remains elusive because proof requires a single anchor that can be cited without translation. The record remains complete enough to keep the city's logic intact, but incomplete enough to keep the origin dispute resistant. That is the durable outcome of the decisions made between 1907 and 1928. The case becomes an object lesson in how institutional reality can be maintained without the kind of documentation historians and litigants crave. It also becomes a lesson in why modern technology does not automatically resolve old silences. Digitization can multiply access to what survived, but it cannot summon what was never filed, or what was filed and later absorbed into private record custody, or what was removed while leaving behind only the marks of its former presence. The restrained question that remains is not rhetorical. It is procedural. If the surrounding evidence can be found in scans, indexes, and digital catalogs, why does the central instrument never appear in any form that can be cited? The block closes on a contemporary image that mirrors the old one. A researcher's screen in 2026 shows a digitized map plate with the parcel outlined and labeled in technical shorthand, a probate schedule PDF with a valuation line that doesn't match its description, and an archival catalog entry that reads, "Restricted administrative hold," with no link beyond the notice. The file is not closed, it is simply modernized, still functional, still incomplete, and still built to survive inquiry without ever yielding the one document that would end it. In 2026, the tools are sharper than they have ever been. Pages once locked behind velvet ropes now appear in pixels. Indices once known only to clerks can be searched from a desk. Maps once unfolded under a reading room lamp now load in seconds, their grid lines as clean as the day they were drafted. And yet the case remains what it always was. Not a lack of information, but a lack of permission. A record can be digitized without becoming available. A catalog can confirm existence without releasing substance. The file can be preserved and still refuse to open. That is the quiet triumph of what began in 1907. A lot in Manhattan moved as though authority had shifted, even when the Registry of Deeds could not offer the instrument that should have anchored the shift. In 1923, Surrogate's Court briefly touched the edge of the same reality, allowing an inventory to acknowledge value without stabilizing origin. Numbers entered where a deed should have spoken, and signatures sat where responsibility could be softened. By then, the chain had already been engineered to survive challenge. Letters carried obligations without carrying the public weight of contracts. Internal counsel reframed formalization as risk. Municipal classification absorbed the parcel into technical language that discouraged narrative. A trust structure tightened control while reducing exposure. Attachments disappeared without leaving an error. Only a thin jacket, a reference that pointed and then ended. And by 1928, the silence acquired its most durable form, administrative vocabulary that could deny access without admitting absence. This is the architecture of power when it does not need to declare itself. In certain periods, an agreement is not sustained by ink and signature, but by the social systems that make contestation costly, reputations fragile, and questions inconvenient. The absence of a contract is not the absence of an outcome. It is the method by which the outcome becomes harder to reverse. A signed document can be challenged. A technical designation can be reviewed, but a gap that has been normalized, treated as restricted, held for maintenance, preserved as private record, does not present itself as a target. It presents itself as a boundary, and boundaries are rarely defended by force. They are defended by procedure. A request is routed, a file is held, a reference is incomplete by a few digits, an annex is implied but never produced. A modern database displays a notice where a document should be. The system remains functional, the official story remains sufficient for daily use, and the question that matters most is left suspended. If the effects are real enough to tax, manage, inherit, and preserve, why was the one central instrument never allowed to be seen? Perhaps that is the most unsettling conclusion this case permits, not that someone hid a paper, but that an entire institutional culture learned how to live without it. The Registry of Deeds can keep its shelves orderly, while the shelf that should hold the contract stays empty. Surrogate's Court can process an estate while accepting language that never fully aligns with the map. City offices can preserve a file by restricting it. Digitization can multiply visibility while still withholding the center. Power doesn't always sign. Sometimes it simply holds. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again, and remain with us, subscribe so that you're here when the next sealed door finally opens. Because beyond these ledgers and corridors, beyond the polite language of administrative hold, there are other chambers, other parcels, other trusts, other agreements that survived only in letters and silences. And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive not because they are well kept, but because the people who feared them built a world where no one could demand the signature.